unreasonable fee charged by an IP would create, issues in future. So what is reasonable and what is unreasonable is only to be decided by the market, participants. So we don't want to get into that. And we have also seen that, of course, this is well settled, but still we find that some IPs do not, see it as an important thing. Non-cooperation of the CD, its promoters, directors, some of the IPs, even experienced IPs, are reluctant to file, 19 application for the NCLT, or there is delay in filing the application. And once it is delayed or the application is not filed, it will only be seen as, a dereliction of duty by the insolvency professional. So please avoid this. At the very first moment, I mean, I'm not saying that immediately after taking charge, you should file an application, alleging non-cooperation by the promoters or directors or officers of the corporate debtor. Please have a word with them. Please take them into confidence. Please make them understand the importance of the process. And please appraise them how you are going to perform your functions, how you are planning to turn around the corporate debtor. And they should also be counseled and, told, their role once an IRP takes charge. So unfortunately, they might lose their seat, if they are ineligible under the code. And then, request, plead. You may have to adopt many psychological, methods to make them understand. And if you fail, then immediately file an application. Tell them, I will be forced to file an application against you for non-cooperation, which will have, effects like criminal effects. You may be prosecuted by the IBBI or the central government or any person authorized by the central government. Then I will not be able to help you. I don't want to do it because I want your fullest cooperation so that all of us, try to revive the corporate debtor. And sometimes there will be no records showing, a request by the insolvency professional to the or the officer to cooperate with them. Please send out emails, letters, and keep records so that you will be able to save your skin later. At the same time, immediately, please inform the Insolvency and Bankruptcy Board of India. Give an email saying that this is the assignment, this is what happened. I sent an email, I telephoned, I sent a WhatsApp message, but this person is not producing their documents. No audited or other accounts are being shared with me. The list of assets are not known to me. They are not providing the list of properties the corporate debtor has. And request, even if there is no request, from you, to take action, we will take up the matter. We will deal with it under the code, under 236. Definitely file criminal complaints against the person who does not cooperate with you. Because unless the important stakeholder cooperates with you, an insolvency professional will not be able to take up and complete the assignment in a time-bound manner. So there are instances of IBBI taken up this matter with the special courts. Many special courts all over the country have taken cognizance of the complaints filed by IBBI. We want your cooperation to stand by what you say, when you are called upon by the special court. If you have a record, please substantiate, corroborate the evidence, and a good message will be passing on to the persons who do not cooperate. Process issues are, always there. Claims updation. Of course, we have come out with, electronic platform and all that. Then another thing is, the role of COC vis-a-vis insolvency professional. the committee of creditors, financial creditors, appoint us to take up their assignment. So we think that whatever COC says, we need to obey. Of course, once you take up the assignment, your obligation is to the corporate debtor first, and then all other stakeholders, because balancing the interest of all stakeholders is one of the prime objectives of the court. So you are duty bound to balance this, because the insolvency professional is the only link between the corporate debtor and the adjudicating authority. COC has no direct access to NCLT. Of course, COC can also approach NCLT for something, but otherwise, you are the link between COC and the adjudicating authority, between the corporate debtor and the adjudicating authority. So you may have to put your feet down if COC is making, unwanted whatever advices or unwanted, expressing unwanted desires, which would hamper or which would affect the balance, of the stakeholders. So you may have to tell them that, of course, this is not permitted by law. We won't be able to do it. Please don't force me to do it. So you may roles while dealing with insolvency resolution process. Sometimes you may have to be strict, sometimes you may have to be a good public relations officer, sometimes you may have to take them on board, you may have to plead, you may have to advise like a counsel, like an expert. So this multiple roles, of course, it is possible only when you take up more assignments and then you get experience from those assignments. Another important thing we have observed that appointment of professionals. This is a very important thing, because COCs may have their own choices of professionals. They may try to use your good officers to engage somebody who is known to them, who is related to them, or whom they are interested and whom they have some benefit out of it. So please don't do it. Please try to appoint only independent professionals. Also, please ensure that the person, the individual you are engaging is a true professional, right? The code provides an opportunity for the insolvency professional to take the support, assistance, and professional services of professionals. It says, IP can take the services of accountants and other professionals. So the other professionals indicate that they can only take the support of true professionals. So don't engage any firm which does not involve in this, which has other goals, and this is not the prime goal of the firm. So you need to be very careful. We have come across many cases, and COCs would also force you to pay the fees that are payable to the professionals who advise them separately, otherwise than the CARP, and they try to include that cost in the CARP cost. So that is also not permissible. If COC or any of the financial creditors, any of the creditors, they want to have their own professionals for advising them separately, let them have it. You don't have any objection, but you are not going to engage them officially, and you are not allowing any money or amount payable to them in the CARP cost. That is also very important. Of course, I don't know if I need to list out everything. In fact, valuers, by the time we are talking about this, I think the law is well settled. Without registered valuers, no valuation under the CIRP can be done. But still, we find that some of the valuers who are unregistered undertake valuation assignments under the code, and that again is against the spirit of the law. Other things, of course, I'm sure that you all know, you must have seen it, and I'm here to listen to you and find out if the various headings that we are dealing with under this particular facilitation letter is all right, or if we need to add anything, if we need to make amendments, because we always want to cherish and share your experiences. We just wanted to, flash it immediately when these things cropped up. So your contributions, your suggestions will be helpful for us to improve it later and come out with more, points, more grounds, so that all of us will be striving to get maximum benefit out of the professional sharing of experiences. Any other thing? Of course, one particular matter I wanted to highlight is regarding the avoidance transactions. Of course, we issued a circular, a facilitation letter only on the basis of certain judicial pronouncements. But now, the other day, we had a judgment of the Delhi High Court, wherein the court has said that the IRP or RP has nothing to perform once the CIRP is over. Of course, we all knew that there is a gap in the legal, position under the code. The code does not specifically provide for pursuing the avoidance applications, because the code only says that the pending avoidance applications do not have any bearing on the CIRP. So that was a matter that IBBI has also taken up with the government. Government is also aware of this. I think this defect may be cured in the days to come. We have witnessed 5 amendments. Other amendments can also be there. There is absolutely no harm in making amendments. That criticism of having frequent amendments is unfounded. That shows the interest of the stakeholders, especially the IBBI and the government, and also our parliament, to deal with the growing challenges in the insolvency resolution system, and to try to find solution to this. I think I will stop it here, and we may have further discussions after Mr. Sanjeev Ahuja has his time, and if there are any questions, we will deal with that those questions also later. So I once again thank ICSI, IIP for having organized this. I think the professionals will be benefited by this. IBBI will also be benefited by what is going to happen in the next hour or so. Thank you very much.
Okay, great. So thank you, Mr. Kumar. Good morning to all of you, the team at ICS, IIIP, as well as fellow professionals and participants. Mr. Kumar, what we have done is, there was a similar session which was there last week amongst the IPs, and apart from the outreach by the IIIP, IPA, we've received some suggestions and feedback from the rest of the IPs and practitioners. So what we have done is we've tried to collate a lot of them. And today, when I speak, essentially I'm speaking on behalf of the IP, the professionals. Now, but I continue to maintain that I'm more of a mediator as well as RP, where if a middle path needs to be discovered or explored, so that at times we feel IBBI as a regulator, as a policymaker, has taken a slightly extreme view, whereas on the ground the practical situations what IPs regularly face, those are actually poles apart, or actually on the other side. So the idea will be to kind of bring up some of these points and also parallelly try and give some options as suggestions. Now, wherever you think those need to be debated further, more than happy to kind of go deeper. And so that's the initial bit. In terms of setting the agenda, I think my suggestion would be I'll take about 5-7 minutes in terms of some other points which I want to make before I go down to respective headings and the specific points which have been there is part of that letter. So I'll probably get started with that. Now, we say common mistakes by the IPs. Now, how many of these are really mistakes, right? Now, that's something which we need to really understand, and that's what I said, the practical aspect needs to come out. And why are they common? So if we say that most of the practitioners are actually committing them, right, knowingly, unknowingly, that means there is some issue with with the provisions or with the understanding, and apparently there is some gray area which is still left. Either there's an issue while drafting, I would say, or there's an issue while understanding, and definitely there's an issue while implementing on the ground. Because it's easier said than done that we all get powers of an MD or a CEO, the powers of the board of directors are suspended, and we actually are there as the person who has to drive the organization. But the only point is these are situations which are hostile situations more often than not. So a typical MD CEO sitting with this entire team of his, the entire hierarchy, the entire board, trying to support him, looking at delegation, decentralization. That is exactly not the case when we are handling a particular corporate data in a very, it's like working against odds. So apart from getting into non-cooperation, situations have been which have become really hostile. Now, what happens? Are we leaving enough time and, potential of application of mind by a professional, or we are trying to kind of put so much of compliances and regulation that most of the time of this 180 days, which apparently, the timelines were the USP of this IBC, which have actually gone for a toss, but we're trying our best together as a team that how we can further bring it down. But in the current situation, what is happening most of the time, we have seen people getting or rather struggling with the compliances on the timelines and the reporting. There's no harm. It definitely is required. The data, the feedback, everything will come to you as a regulator or IPAs. It will come through us only. So that point is well taken. But the kind of pressure we already are facing in terms of the strict timelines and the kind of data and the load of data which we are supposed to keep sending back, the concern is that takes a lot of time. So yes, it's evolving. We are trying to kind of streamline the process. We have seen IBBI working, IPA working. I'm sure there's still enough which needs to be done. So from that perspective, this dialogue has to continue, I would say. So the more we interact, the more we get to understand that, okay, these are practical difficulties. Let's try avoid duplication of sending data to IPAs or IBBI, time and again. So those things probably are going to help in terms of leaving enough time with the professional to really concentrate and think out of the box and look at creative solutions as far as managing a corporate data is concerned. And I just repeat once, this is against all odds. This is not a scenario where everyone is giving you a red carpet welcome, right from a CD, promoters, employees, KMPs, whatever it might be. The guys who've not got paid for so long, and the COC, the lenders primarily, who are only primarily worried, and I'm making a statement here, who are primarily worried about the recoveries. So this entire mindset of resolution versus recovery, a debate which continues for forever. Who gets stuck in between is the IP, because that's what it is. I read the charter, I read every time the BLRC, I read the reports, I go to the court, I understand the intent. But there is someone who's driving it from behind, and they say, boss, I need my recovery. You get me my money, otherwise there's a pressure. So there is a tug of war. And the point is, someone like us, who's an individual, he gets stuck in between. So that was one point which I wanted to make. Can it be the case, as I said, that somewhere the policies, guidelines, provisions which are being recommended by regulators are actually having some practical difficulties or some inconsistencies? So these discussions will bring those inconsistencies out. Yes, I agree. Some DC cases have brought about the potential gaps in understanding of the applicable provisions. And of course, maybe we need more clarity, because I keep saying, as a professional, I do not have any incentive to not adhere to a law. When I've cleared my exam, when I've gone through my trainings, and I'm taking it as a serious profession, as a career option, then I do not have any incentive. I mean, why exactly would I say that, out of 10 provisions, I'll only apply 3 and not the other 7, or the vice versa? I'm interested to comply with all 10. If I'm not able to, I'm sure there is something wrong, right? So there's no intent. Equally important is, which I want to say later, but I think it's appropriate I say now. Yes, there have been disciplinary actions, and we all are concerned about it, whether it's happening, because at the end we are part of the same community. So if 5, 10, 20 people, they have issues about either certain allegations, some violations, whatever gaps there have been, whether it was because of intentional, non-intentional, or because of the pressures, the reasons might be whatever. But one suggestion and one request I want to make is, we have 3,500 professionals today. Okay. Now, if there is a 1%, 35 people, or 2%, 70 of them commit a mistake. Again, I'm making a caveat here, knowingly, unknowingly, separate discussion. If 35, 70 odd people make a mistake, should that mistake be termed as common mistake? One concern. Should every one of the rest of it should be termed as, all on the same footing, that, because 15, 20, 40, 50, 70 people have committed, so rest of them are also on the radar because of that? I mean, that probably, is like putting the cart before the horse and actually painting everyone with the same brush. So that also comes out at times, which is a bit painful. So again, these are all collations, and I keep repeating that it's important, it's coming from the ground. So I think it'll be nice that, we are heard there, and it's taken with the right spirit. Now, yes, I would definitely urge the IBBI, IPAs as regulators on behalf of the fellow professionals. Sir, this IBC implementation is going to be a team effort, right? Day one, wherever when we read the code, we were told there were 4 pillars, and fortunately IP is one of them. But time and again, it so happens that the load on the pillars is not, it's not maintaining an equilibrium. So if any of the other pillars is struggling because of evolution of law, or we're learning, or the dust is yet to settle, or there is an amendment, or we need to put a process in place or infrastructure, in the interim, this entire load comes or gets shifted to one pillar, which is the IP. And somehow it so happens, out of the 4 pillars, 3 are institutional pillars, 1 is an individual pillar. Right. So, I mean, yes, in few forums you've said, three tires of a truck and 1 tire of a Maruti at a trip. So that's kind of, make it a wobbly, journey. So we need to be, mindful to that. That's important. So essentially all I'm saying is it started as a team effort, and definitely it will move forward only if it continues as a team effort. So that is, another point. So essentially whatever gaps we all discover together, they need to be plugged together. Okay, because otherwise, for the rest of the world, whether we call ease of doing business, the World Bank studies, or we take care of or we think about the other stakeholders, industry, MSMEs, everyone is going to blame IBC as one single blame, not realizing what actually went wrong. So we are in it, together in this entire thing. So the success lies when we all share the load. That is, I mean, these are slight general comments. I'm not kind of getting into too much of specifications here, but the intent is it continues to be a team effort. So somewhere at times I have the feedback. I personally feel this seems to be a trust deficit, right? Maybe these guys have, an agenda or something like that, which is not the case. When everyone has cleared the exam, when everyone has gone through a 50-yard training or something, we're all equals. Everyone comes with 15, 20, 25 years of experience. They have been managing their shows, their own P&Ls, whether they were part of corporates or into practice. Yes, a lot of us may not have the experience in terms of managing a company, right? I continue to say that, whenever I take as a faculty, I kind of, take either a management session or otherwise, I do tell, if you have a corporate experience, definitely is going to be giving you an edge. Agreed. And if you do not have, then you need to have some more learning. And how do you kind of fill the gap? By getting some people as part of your team who have a good understanding. So all that is fine, but there's a learning process. So somebody who started in 2017, he still has gone through, he's gone through the roller coaster, whether through direct engagements or being part of other teams or attending sessions. Whoever is coming to today, as a new IP, I'm sure he on one side has a benefit of hearing from people like me and you and attending these sessions, but they would also need some time to go through a certain drill. So unless until people do something on hand, the best learning is through the experience by doing on your own. As I say, proof of pudding lies in eating. You have to wet your feet to kind of start swimming, not by reading a book. Something similar. So these people again might have some mistakes, and those mistakes will be unintentional. So are we thinking about the new entrants, or we are saying that once a rule is made, so a guy who has a 4 years experience versus somebody has just 4 months who stepped in, they'll behave in a similar way? Answer is they won't. So something will keep happening. So are we differentiating, or we are I'm saying that one rule applies for everyone, and henceforth margin of error is zero. So those are few things. On a lighter vein, I would definitely want to say that good that you listed down the mistakes or the shortcomings by using alphabets. So you had to finish it Z, A to Z, only 26. What if you would have taken a numerical number? Then I'm sure then it would have been infinite. We would have still been discussing 100 or 200. So good that we chose A to Z. Okay, a small suggestion to ICSI, the IPA team, as we go specifics on one-on-one, with the respective points. The coordination team, I would request, let's collate the Q&As, which will keep coming as we speak. One, so that depending on the topic or the particular point which I take, Radhika, if you can after my initial comments on each of the topic, if you can say, if you can just apprise us of the specific queries regarding that particular subject, maybe one or two, so we can pick it up. One. And at the end, because this session also gets recorded, so my suggestion would be that all the suggestions, practical difficulties, recommendations, suggestions, what are coming, let that kind of get collated. Let's put up a white paper and get circulated across, which means it has to go to other IPs, it has to go to IBBI, and it should be circulated with the people who are with the participants who are kind of attending today, so that we all broadly know that having spent 1.5, 2 hours, whatever time we spend, this is what was discussed, this is what came out of it, and that's what they can look forward to. So that is one. Sir, just to, before I begin, one very important point you kind of mentioned about the fee part. Now that continues to be a very sensitive topic, and day one, let me tell you, it's strange. I understand that on one side it's it's a new profession which is kind of coming up and taking a shape, but most of us, every one of us, has been managing our P&L. We have already had our clients. We knew how to negotiate. We knew how to kind of get money and all that. And there were ways to kind of negotiate, maintain relationships, and everything. What happens here is we are stuck in between a market-driven fee, but then getting a diktat from IBBI, it should be reasonable. Now, if you say whatever market decides, are we saying let the market decide? In that case, if it's reasonable, unreasonable, let the guy suffer or let the guy take the benefit? Because that's the market which is deciding. But in the very same breath, we say it should be reasonable. Now, and nobody is willing to define reasonability or the term reasonable. So we use it with enough leniency. But my point is, it's just impractical. I mean, how do I define? I mean, I can actually go ahead and say, okay, let me put a structure or a fee structure. Let it come from IPA. I'm just giving you a scenario. Let's put a structure that, okay, for these kind of cases, whether you're talking about a percentage or a fixed amount, this is the asset, this is the loan, let me put a number. The flip side, as is always the case, every coin will have a other side. I say that, okay, the moment we say, let's put a number or a table or a schedule, what will happen is it will be totally on me to accept or not accept. That means to bid or not bid, right? Are we wanting to get into that stage? And if we are not, then let's decide either we are totally out of it, let the market do whatever it needs to be done, because these are professionals. They need to kind of be aware and concerned about their revenues, how it needs to come. Of course, everything has to be legit, everything needs to be transparent, everything needs to be disclosed, to be recorded. All that I'm totally with you. But when I keep hearing that after 4 years, almost 4 years of IBC in place, the very basic point, how do I get remunerated? How do I get compensated? What is the fee? Who will decide whether I will get? It needs to be reasonable, but I need to be careful about the market also. And the best part is the bottom line, there is no assurance that I'll get, even if I have negotiated with the applicant of the COC. And as I heard from you, NCLTs, NCLATs, apparently may not have jurisdiction, then who has? Because, as a lawyer, as a CA, you do it differently. But as an IP, I'm stuck. So I negotiate, but there's nobody who can assure me I'll get it back. So I'm saying there is some gap in between. Okay, it can be a debate for another day because it's a topic which can go for 2 hours. And there'll be people, the rest of the participants who would want to kind of share, their views on this thing. And it'll be nice to pick up general issues and specific issues also. But since you brought it up, I thought it would be very appropriate to at least share my thoughts. We are still struggling, and fee is so important. If the person who's come into this profession and taken to the career option, if he's not assured about the fee, then I think this entire it'll fall as a pack of cards. Because how do you keep yourself motivated? I mean, I wish we were doing it as pro bono, as a kind of charity in addition to what we were supposed to, which is not the case. So somewhere this requires a discussion, right? Whatever time, whichever way, whosoever you think is relevant to be brought in, it'll be great to get a couple of banks. It'll be great to get a couple of operational creators and maybe likes of home buyers, IBBI, IPA, and some of us, because this needs to get settled and ASAP. Otherwise, a lot of issues are interdependent, but this somehow seems to be a continuous pain actually from day one. And I feel pained about it. So that was it. So anyway, just kind of took one point out of turn. So if it's okay, I can go quickly one by one. Looking at time, my suggestion would be that there are few of the observations by the board in the paper which are pretty much well accepted. So there we won't spend much time. Maybe I can quickly say that okay, this is accepted and this is what we did. Or if there's no other feedback or suggestion, but some of them I'm sure will probably require your views, and maybe we'll be able to kind of take a couple of queries on specific. So if that's okay, I can get started. Right, sir? Okay. So and Radhika, I mean, as I said, it'll be nice if you keep a tab on the Q&A, and depending on the point which I am at, you can bring up 1 or 2 queries regarding that. And at the end, we need to collate and probably circulate it as a white paper. So first point is assignment without having authorization. So my view here is AFA started with a basic premise that the way we have a CPERs in any profession, continuous professional education, I think that was the genesis, that was the thought process. It started well, I mean, as a topic. But over the period, what we've seen is I mean, there are a lot of things, everything kind of got added with AFA. Now this has become a kind of a complicated thing. And this apparently will be also potentially used as a tool that no, you can't do it because something has not been completed by you, whether it's procedural, technical, a show cause notice, even you have not accumulated so many of number of hours or something. So too much of it is getting connected to something which was as basic initially as a CPE. Yes, a lot of it has already streamlined. Other day I was looking at the site at IBBI. I'm part of a couple of committees at IPS, so we keep discussing how further we can improve it and streamline. But a small point which I want to raise, and this probably also needs to be taken care of. Example is your CPRs, or depending on how much sessions I've attended and what I've done it all. Somewhere I'm seeing the onus is being put back on the participant to prove that, I have been here and I have done this at this point in time with a limited window and all. I'm saying we are using technology. Whenever there is, by using technology, we know like who's attending the session. Now we're not taking any exam that you've attended a 2-hour session. So, list down, this is the query and give me answers. We are not doing it. So we are saying that, yes, it's left to the professional. And today we are talking about a webinar, but tomorrow it will be a seminar as well. And frankly, if we say that somebody will switch on his monitor and go to sleep, similar things sir happen in seminars also. People all the way they'll move out and also we are not concerned about the exceptions here. All I'm saying is let's use technology, reduce the burden and the load on the professional of trying to then justify that, okay, I was there for 2 hours, this was the time, this is what I did, it all not relevant. So small thing, this is something which has gone to IP as well. But if you feel that it's relevant, smaller irritants can move out. One. Second thing is AFA at the time of consent or AFA at the time of appointment. Consent is something an IP is well aware of. So if tomorrow an applicant comes to me, a potential applicant, I know I have an AFA. Hence, I'm eligible. I have, a legit right to give my consent. What happens? I have no idea, I have no control on the applicant. When does he file? When does it come for listing? And when eventually it will get admitted? Now, if this admission happens whenever or probably after the expiry of my AFA, I'm not saying I won't do whatever I need to do to get the renewal done. But there can be a technical issue. Examples I've said about the CPRs or some other technicalities which come in. How can I be held responsible when I gave my consent when I had the AFA and I was eligible, but at the time of appointment, I do not have it? The reasons can be different. One question. Second is, are we also thinking through the process and say, okay, in case you get to know that your appointment has happened by through the order, and you get to know by the applicant, by the NCLT, whichever way, and you want to withdraw because you don't have the AFA. Again, we're not getting into the reasons why. If you don't have the FA, have you thought about how can he actually inform the relevant stakeholders and say, guys, I'm sorry, that time I had a FA, today I don't have, so I can't accept this appointment, right? Maybe we need to think through, because we need to give an option. If somebody is ineligible, if you're wanting to pressurize him that, guys, be aware, be sure that you have the AFA all through. That means in case he cannot, for reasons, to be discussed later, but in case he is not, are we giving you an option to say, okay, please inform these people and you won't be able to get an appointment? That means NCLT might have to choose somebody else, or the applicant might have to be ready with an alternative. So these things are essentially important if we think through what we are trying to achieve and how it will pan out. So these are my 2 points. And of course, sir, section 9. So I think this is what I wanted to kind of say about this. Do you have anything to, add on this? These were my kind of, couple of things which we have collated. Anything you want to say? Otherwise, as in when you say, I probably can move to the next one.
No, we'll move. We will move on.
Okay, great. So second point is the fee payable to IP. Of course, we did discuss out of turn, but couple of quick points here. Regulation 33 says the applicant has to be committal. He has to. So it's a bilateral contract between the IP as well as the applicant. Regulation 33. There have been cases where the applicant is not paid, right, in spite of the agreement. Now, are we expecting? I'm not saying immediately we need to have an answer, but let's think through. Applicant refuses to pay or he delays. The very third day, you have to be out of your pocket because you have to put a public announcement. And then eventually you engage your the team starts working, and 1 month today the concept of IRP is no more. The lines are blurred. But assume that applicant only appoints or nominates the IRP. But even for that 1 month or whatever time initially, he's the person who's responsible. If he doesn't pay, in spite of the agreement, what happens? So we need to think through. And if it's not happening, then the option to IP is what? If there is no money in the CD, just to add to the problem, He goes to COC as and when the COC is formed. He says, I am out of pocket. Applicant was supposed to pay. He is not paid. Now, applicant, after paying, if it doesn't get ratified, he doesn't get reimbursement. But if he is not paid at all, and COC says, go and take a work because he got you appointed. So go and take money from him or else go to NCLT. Now that poor guy has to hire a counsel for his own money and spend and be out of pocket further. So, the more we get deeper, it kind of throws up a challenge. Now, that individual who's to immediately go and take over a company, run it as a going concern, but what is happening now? He's saddled with a problem, no money. What about my other professionals which I have engaged? How do I continue? COC is refusing. Now I have to go to NCLT. So he's adding to the litigation. The guy who was supposed to resolve, he on his own is adding to the litigation. That is one point. Second point is, if as and when NCLT appoints a professional from the panel, right, primarily which is happening in Section 9 applications, the IRP, the potential IRP, has no clue about the CD as well as about the applicant. Now he reaches out to the guy and says, your applications got admitted. I have been appointed. Pay me some money. And says, no, that was never a discussion. I never wrote. I never gave any undertaking anywhere. Some benches over the period started by saying 2 lakh, to be given by the applicant. If it's written, how many of the applicants agree? If it's not written, then the chances of that agreement or something are in any case reduced. So this thing further kind of adds to the problems. I'm not even discussing when COC agrees and still doesn't pay. That's a separate topic. So we just take it out. So these initial, the points which I've shared, we need to be mindful of that. Because all I'm saying is, I'm not saying that you need to have a direct answer or a ready answer or unless until we have the answer, things won't move ahead. My problem is these are irritants for the professional on the ground. As a regulator, IBBI, as IPAs, I think it's very important to be mindful of the problems what the practitioners are facing on the ground. So if I make their life easier on one side, their concentration will be absolutely to kind of continue with the process, adhere to the process, timelines, going concern, everything, because they would be assured that this part is getting taken care of. So that was because let's not make us entrepreneurs. We are service providers, right? We are not in to invest money. For example, the very third day, if I have to write a check to the publication guy, imagine that nowhere in the the code or provision is written that I have to invest money, right? And who will pay me, when they'll pay me. So it's a discussion which is required. I'm sure this will get connected to the fee part, because fee and expenses, they'll go hand in hand. And of course, the IRP cost or the CRP cost includes the expenses as well as the fees. So we can take it together, but since this came here, I thought I'll kind of just raise it. Anything you want to add, sir? Anything or query or something? But I'm keeping you posted with my collation and feedback.
No, some of the issues we have just discussed have answers, and some of them do not have ready answers, as all of us know.
Okay.
If you ask what is the real mistake and what is a genuine mistake, what is the mistake that is done unknowingly,
yeah.
This is individual assessment. Sometimes we tend to neglect a certain thing because our focus is on the main process, and we tend to ignore. We may commit something which is without knowledge or without proper understanding, and then we ignore. So this is something that we have to find out, what is the genuine, the real mistake, and what is an unknown mistake. But of course, the treatment of both things should be different. I fully agree with you. It's not a kind of generalized thing that there is no watertight component, in this.
Sure.
It's only natural. Even an experienced professional may commit some silly mistake. That happens. It is not happening only with the insolvency profession. I have seen it. Being a lawyer, I have seen it, in legal profession.
Sure.
The most experienced lawyer The biggest lawyer practicing in Supreme Court also sometimes commit mistakes. Maybe, an error of judgment, thinking that this is an area where, we don't need to bother about much. Let us focus on only the main, area. But there must be, some problem, that ignorant area or the symbol area that would affect your particular assignment. So that's why we are saying insolvency resolution process is like a war. Our strategy should be, to have a comprehensive attack. Let us not leave any room for, failure. So we have to have a bird's eye view on each and every point, each and every decision that we take. Then only we'll be able to, avoid such mistakes. You talked about mediation. If you want me to address mediation right now or otherwise later.
I would suggest later because,
Yeah.
maybe we can devote 5-7 minutes.
Yeah.
It'll be interesting to kind of discuss that.
Yeah. You said, for 35-40%, should we accuse all the 3,500, IPs, and should we look at them at the same, level? My problem is, when we think of insolvency professional, especially when this is a new profession in India, and this profession is, yet to stabilize properly. So if we allow 35% or 3.5%, to commit error, and then it would affect the whole profession. We need to preserve this profession. I fully agree with you on this point that this is a cooperative process. I don't think that one pillar can, take up the greater load, and other pillars can, sit comfortably. That is not the idea. IP is one of the most important pillars. I put it the most important pillar, because without IP there is no process at all. Everything revolves around the strength and capability of insolvency professional. All others are to support you, to share your worries, they share your agonies, to share your problems, and to help you in successfully completing the process. Of course, all the pillars of insolvency ecosystem have their own problems, their own issues. If in the insolvency and bankruptcy, another pillar is having load, I respectfully disagree, because the kind of load that we bear is unimaginable. We have to bear the brunt of many people. In fact, we are accountable to the government, we are accountable to the parliament, we are accountable to the judiciary, we are accountable to you and all other stakeholders. So we are all sharing. I'm not saying that we are sharing equal load, but our load may not be publicly displayed. You may not know what kind of load that we take. We are not in a position to share our woes with the other stakeholders also.
Agreed.
But we are managing. And I fully agree with you that we need to strengthen our capabilities. We all should strive to complete the process with one mind, one spirit. Otherwise, if we lose the team spirit, we will not be able to sustain this new regime that we have. Then you talked about IPs need to have some drill before they actually I don't know if I have understood correctly. I don't know if any other profession has a mock before they actually take up the real process. Maybe doctors may dissect upon dead bodies. I think that may be the only exception. Lawyers, chartered accountants, company secretaries, we do not have that kind of a facility. But what we generally do is to take up small assignments, less complicated assignments, and learn from that experience, and then we will be able difficult assignments. I don't think that any raw IP will be given in charge of a biggest a company which has the biggest problem, the process which is highly complicated. So I think that would be the answer to that. Of course, fee again, contentious issue you have touched upon, Mr. Ahuja. My only take is, should we actually deal with the fee issue at all? I mean, if IBBI starts regulating fee, I don't know if there will be 100% support and appreciation by the insolvency professionals. Then there could be issues that you will be tied down to certain bracket. You won't be able to get the desired fee, because fee depends on the nature of work, the effort, time, energy, complexities of an assignment. If the assignment is complex and the CD is position is better and COC has big exposure, I think there should the professional should be able to negotiate maximum fee. I am saying the professional should get maximum fee depending on the complexities. I am for good fee to the professional, because unless you charge a reasonable fee, you will not be able to freely and independently deal with the process. If the fee is limited and if you have little dissatisfaction, then you won't be able to do complete justice to the assignment. That is my experience as a lawyer for some time. So that's my
answer. That point taken. I mean, on the fee part, I think what I was trying to say is that we hear the board, we hear IPAs, and we hear at a lot of sessions and webinars that you don't want to regulate fee and you want market forces to determine the fee, and we're totally with you. But then parallelly, what I was suggesting, that at times we again keep hearing through various communication letters, and now this is again somewhere mentioned in this letter also, it should be reasonable. So what I'm saying is, if you're leaving it to the market, let market decide what is reasonable or unreasonable. Coming from you as reasonable and then also saying in the same breath, let the market decide, I'm saying let's be clear that if the regulator feels, and what I hear from you is rightly, that you don't want to control, influence, or have anything to do with it. So I'm saying let's kind of totally delineate, but maybe one session, with IBBI, with the IPAs is important, just to kind of apprise you what's happening on the ground. And the only example which I gave was, what if you were to actually put a kind of a schedule? Everything always will have a flip side. Now you would say that, okay, we have monitored the fee or we have decided. Some people will say we don't like it. Some will say at whatever cost I'll do it. You'll always have both kind of people. Today also in market, when market is willing to kind of give you X price, there are people, either they're not getting the job or they were desperate or whatever be the reason, they are wanting to do it X by 10 at at a cost of X by 10. So this kind of situation or exceptions will always be there. Suggestion was, I mean, not today, but maybe one of the sessions we can exclusively dedicate to the fee and expenses and anything and everything about it. So what we'll do is we'll kind of connect all the issues which are arising on a regular basis, so that it's very clear. And maybe one note from IBBI, guys, take care of it totally. We have nothing to do with. Maybe that's a call we'll be able to take. But a debate for a separate day. So,
I agree with you. We can have a detailed discussion on this, or maybe many more discussions, till we arrive at a conclusive decision. There is absolutely no problem.
Great, sir. Great. Okay, so I'll move forward. Then the third point was application for cooperation. Now, you've already in your opening remarks spoke about 19.2. Now, it somewhere says file the application wherever required without any procrastination. Now, my case is, a lot of places we keep saying an IP, a professional, has to apply his mind, right? Now, when he's applying his mind, let him apply his mind without any kind of pressure. What will happen is, how would you define procrastination? You go somewhere, you are a stranger, you are an unknown animal to the cooperator and the KMPs and all. Nobody has idea. Half the time, people have a fear that the company is out of their hands forever, for good. Looking at whatever has been their experience or whatever their consultants or advisors told them. So what happens is, it does take some time for a new guy who's though an appointee of the court, by the court, with whatever powers under 17, 18, 20, whatever be the section. The problem is, these are all relationships we're talking about. You step in somewhere, so from a situation of so-called hesitation to a non-cooperation to a hostile environment. So there are degrees, and one really has to work through all that. I mean, my personal case, I was welcomed by bouncers when I stepped in somewhere. Now that guy has no idea. What do I do? What exactly is my plan? Am I actually want to take over the company from him? Now they don't understand we are a caretaker, professionals who have been sent for 6 months or 9 months, and we'll kind of run the process and we'll figure it out how it can be resolved, restructured. There can be 2 points. One is the guy understands that. The other thing, he continues to be skeptical because either he's not being guided properly or he has some vested interest. There's a siphoning case, he wants to hide and all. So my point is, it does take time for a professional to make up his mind that yes, he's tried whatever he had to. He's tried the psychological part, he's tried reaching out to the people, the KMPs, the promoters and all, and bring it to the notice of COC. Now, at a point in time, he thinks it's totally beyond me. I need to reach out to the NCLT. But the way it kind of comes out, frankly, and yesterday apparently, we were invited for a roundtable on ethics, some document which is being prepared. And again, there was a lot of discussion on 92 and avoidance transactions. My point is, the more and more we discuss, it's almost as if we are endorsing the extra litigation at the drop of a hat. Think later, file the application first. Right now, that should not be the message. I'm not saying that is the message or the intent, but all I'm saying is, the more we keep saying, we are taking out that the application of mind by the professional who, again, I'm repeating, 15, 20, 25 years experience. Now, if these guys have really not done anything in life, and then they kind of screw it up for ABC reason, again, sir, that'll be an exception, an outlier, which cannot define the rest of the guys, because you'll always have people making these kind of mistakes or calls, and calls also going bad in hindsight. If I rely on a team of corporate data and they have a vested interest and they tell me only half of it, I only rely on that. And when it doesn't add up, and 2 months later, I said, guys, this is not the full picture. I have a problem. Either when I'm creating an information memorandum or something, that's the time when I'll actually figure out there is a agenda. That's the time when I'll actually run to, the adjudicating authority. Have I delayed? No, I tried my best. Now, how do I tell people that this was not procrastination? Otherwise, what will happen is, people to be on the right side of law and reading all these things, they'll say, "Ki boss, pehle mahine mein, by the time you create a COC, you tell the COC, guys, I've already done a 19.2. Now you are actually adding to the problem." So, I mean, that's my, again, suggestions or the feedback coming from the thing. So happy to hear you on this.
My simple answer to it is that being a professional, an insolvency professional, should invariably possess, good olfactory sense, if I put it rightly, because you will be able to sense, the intention. Of course, as you have said, this can be acquired, by experience over and over again. But, you should try to understand the person, the way they behave, the demeanor, and you should start your war room preparation for 19.2. I mean, I'm not saying that you should tell them that you are doing, but you have to display the adjudicating authority, IBBI, that you have started preparing for 19.2 from the very, when the first time when you ask them to cooperate, to provide accounts, audited or otherwise, to provide the list of assets, and you should ask them to allow you to inspect the factory premises or whatever, and start collecting evidence. You are a prosecutor, you are a lawyer, you are a person who should be able to investigate into the affairs of the corporate debtor, because once you are in charge, you possess the keys to the treasury of the corporate debtor. You should know the business strategies, the business interests, and the business processes, and you should sense that this guy may be evasive. You may get a lot of information about the promoters and directors from the market, from their own employees and officers, and also from them directly. And this is how you should develop your psychological attitude and attitude to understand people. So please be able to display that you had already started preparations, and you filed the application only little later after exhausting all means. Yeah, you felt that yes, this is the right time to do it, because unless I do it, these guys are not going to cooperate. So not that having wasted so many days, and then you are not able to demonstrate that you had taken some steps, you have been waiting for this opportunity, so then you'll be in trouble. So that is the only thing I'm saying. You should develop a good olfactory sense.
Sure. Got that, sir. And maybe just to kind of add, and I mean, it can be noted by by the team also, that since 19.2 has come as part of the letter, and we attribute a lot of weightage and importance to this particular action by the IP. I am not saying that you can actually direct NCLT, but somewhere there has to be a dialogue that the moment 19.2 comes, that needs to be treated as urgent application, needs to be disposed of within a week. Because what will happen is, sir, if it goes into, in the list or in a sequence or in a queue, then the whole purpose of 19.2 gets diluted, and the promoter or the people who are not cooperating, they get real boost in terms of, and one bad fish, you can understand that what will happen is this goes in the market. It doesn't matter even if it's the 19.2. So maybe a thought that let that take a shape of an urgent application by default. Okay, next is public announcement. So broadly, I'm absolutely okay. It has to be, it's very clear, the law, 2 papers, a registered office, principal office, where maximum, operations are happening. So more and more people get to know about, and then they can file the claims. Equally important, my suggestion, wherever people have doubt that, this only one state, 2 states of something, try and negotiate. Today, the rates are much more reasonable. They should look at all India also, if the company has transactions all across or something like that. But a small concern, which again was raised by one of the participants earlier, it probably came on the WhatsApp also, that Section 9 applications, right? Section 9 applications again, throw up a bit of a challenge where you get to know middle of the night that you've been appointed, 3 days start counting. And by the time you need to kind of really understand that where is the CD, what is the CD, how do you get details, your 3 days, 4 days, 5 days are over, and you're still struggling to figure out where's the registered office. And unless you have an adequate number of details, not everything is available on MCA or Google or Zob or wherever, and not everyone is a company secretary to be, on top of it. So, and you can't even prepare, because I'm talking specifically about the panel appointments. So some leeway, again, leeway not required. But maybe at the time of when the order is being reserved or almost about to get pronounced, is there a way, again a suggestion, is there a way to reach out to the a potential IP who will apparently get selected or appointed, so that he can have his antennas on that time? I don't know how it works, because right now most of us are not aware as to how does NCLT really pick up a name from the list what they have. So if there is either clarity on that side, or in any case, they apprise the potential IP that guys, maybe in a week from now, there can be an order or something, be prepared. I don't know if that helps. But something has to be done as far as the panel thing is concerned. Otherwise, public announcement struggles.
Yeah, I share your concern. The same, I'm on this. this issue, Section 9 application and the related fee and expense thing is always a challenge.
Yeah.
You mentioned about, NCLT is fixing 2 lakh rupees and all that. I don't know if that 2 lakhs is really paid.
It's not a standard. It's not a standard. Yeah.
It's not a standard. Be a bottleneck. We are also aware of this. And let us discuss this and try to solve this.
Sure.
If this is not an issue that can be easily solved, then I would also wanted to add to the, giving instruction or giving apprising NCLT on the need to deal with Section 19 applications. It's a real challenge. I have seen,
Right.
months together, even years together. I'm saying, it's very sorry to say, NCLTs are sitting on this application. There is absolutely no use once, the NCLT takes up and finally passes an order, much time would have wasted. So that is a real challenge. We are trying to take up with the judiciary, with trying to apprise them in judicial colloquiums and all that. But then they have their own, complaints because of the lack of proper infrastructure and other things. So it's a vicious circle. We are unable to solve it, till now. I think sooner than later we will be able to deal with it. This is to be dealt with immediately. And 19.2 applications should get priority over other applications because the IP has approached you as there is no other way but to, to come to the NCLT with folded hands. Please help me to complete the process.
Right, sir. Right. So, though, this was a suggestion which I want to make at the end of the discussion, but maybe, it merits to be spoken now. So when you say colloquium of judiciary and all, I think it will be great if we have not very frequently, but on a regular basis, interaction which is off court, right? For an IP and the bench members, including, maybe some of their staff. Now, the reason is they need to really hear from us directly as to what the problems we are facing, and they have to come back that, is it only the infrastructure or there is a lack of, some inconsistency in some understanding in terms of priorities or sequence or something. So some interaction with you as IBBI sitting in between will be a great help for bridging the gap in case there is any. So, whenever it's possible, it will be nice to have 1 or 2 roundtables at certain intervals so that, we get to hear each other outside the court, because the protocols are very much different in that case. Fair enough, sir. And third thing was, okay, after public announcement, updation of the list of claims. So broadly, this is very much okay. This needs to be updated. So I don't see, much of a discussion here. Yes, one small concern is the code says updation of the list and display it on the website, if any of the CD, right? That continues to be there, if any. Now, the latest, one of the communications says that even we need to put the details of the creditors to IBBI. I think I'm sure, you must have thought about it, but otherwise an administrative nightmare to keep getting, so much of data, and what do you do with that? Somewhere, let that come maybe as a provision, as a regulation or something, some mechanism to probably, set up a website. It's not that, so many things have happened in the interim. Say that in case there is no website of the CD, or if they are not providing you with the details, because half the time we have figured out you don't have the password, you don't know where the server is. Long time they have not kind of renewed their, the payments and all that. So today it's absolutely, it's not costing much. And it's again a matter of time that, when some vendor sees this opportunity, and there are so many in the market that, this will be a option, they'll be more than happy to kind of, set up a very small basic thing. So at least what will happen is there'll be something available for the world to see as a communication window. I don't know. Have we lost Mr. Kumar because his screen went blank? Radhika? Okay. Yeah, he's back. Apparently, right. So
yeah, I think there is some issue.
Right. Otherwise, my suggestion, sir, in case you're feeling there's an issue with the bandwidth, probably, you can switch off the video for a while. That should be okay. It'll help, the audio to be good. So that is one. And right. So this was just a suggestion. I mean, if otherwise it's not posing any other problem. So maybe a CD thing can come as, or sorry, a website as a CD can come as a, as a suggestion, as a directive that, yes, it should be created. And that doesn't take much time. So you're saying by the time RP is putting up a COC, you have almost a month. So that should not take much time. That's a suggestion.
Yeah,
Authority of
that's a very good suggestion.
Right, sir.
That's a very good suggestion. Yeah.
Okay. So the next point is authority of COC. The code read with regulations talks about responsibility of COC in this thing. So section 28 is one situation which is very clear that these are actions which cannot be done or undertaken by the RP unless until he has the approval. So I think it doesn't require much of a discussion. It's pretty much clear. The concern is at times it says joint lenders forum or a particular creditor, he tries to influence the RP. So here the suggestion is that why it happens. It's important to kind of drill down a bit. COC comprises of primarily of course it's the financial creditors, but out of those financial creditors, primarily these are the banks who have been dealing with the corporate for so long. They understand the corporate, the promoter, the seed, the KMPs and everyone much better than us, number one. But more important is today what is happening because of the requirement of an IP to be on their panel, right? So at times, whether we like it or not, said unsaid influence is there. So if the same FC is sitting, right, who's on whose panel I am or I am not, then there is a unsaid influence. Though the complication does not end here, because I don't know that FC has adequate voting power. Would he be able to really, fight it out with the rest of it? Because COC is a heterogeneous group. So frankly, what happens inside is, it's only, depending on once you grapple with the situation, you get to know. But the only point which I was trying to link with, why does we get to see or hear cases of influence? Influence is primarily one of the reasons. These are not all the reasons. One is that everyone follows the big guy out there. So the big guy by default thinks that he's the boss the way he used to be during JLM, irrespective of the percentage or the voting power. Second problem is about the potential this panel thing. You are not on my panel, I can chuck you out if you don't behave, something like that. Or by default, I will take you out. So again, this needs to be discussed, not here, not now today, but otherwise authority of COC has been very clearly laid out in the code. There have been a couple of papers or suggestions directed from IBBI. Do we understand IBBI does not have jurisdiction on the bankers or NBFCs, but even if it has come as an advisory, let me tell you, sir, on the ground, not many people, they really appreciate that or respect that. Not much of awareness is there, and B, they are part of a different system. They are guided by different policy. They have to go back and report to their own bosses depending on the hierarchy they are part of. So even if they read, even if I tell as a chairperson of the meeting that this is what the advisory is for you guys, I mean, this not many of them, right, appreciate that. So from that perspective, there have been issues which continue to be heard across. But yes, at the end, independence of IP should not be compromised. So we need to really find out reasons how it is being compromised or how a IP is getting influenced. Panel to me is one such area. If we are wanting to take it up separately whenever, and just to try and understand, IBBI creates a panel. I understand we are all equals. But a particular bank goes ahead, creates panel, and then there are other people. Everyone has his own criteria. How can you start discriminating amongst the same people who are otherwise who've cleared the exam and who are there? So if you are going in detail about checking everyone, did we have interviews? Are we saying that IBBI's panel is inferior, but they know how to kind of select people? Most of them had panels about CA and lawyers and all. I feel sorry. You cannot hold IP in the same category. IP is going to run the entire company. IP is not a CA. He's not a lawyer. He's not a company secretary. He's much more than that. And you do not make panels of potential MDs and CEOs like that. So somewhere some discussion has to happen so that this is not misused. That's the only concern. And that's why I see a linkage in terms of the compromisation, if at all. So that was the point made. I mean, frankly, I mean, I don't, I mean, you want to make any comments, sir? I can move otherwise. You're on a mute, yeah.
Nothing.
Okay, great. So the next point is appointment of professionals. This point is again valid in terms of that the professionals who are to be appointed, they need to be like, actually required to to ensure that the process is carried out nicely and all that. My concern and the concern what I've shared by rest of the people is, again, there is a reference. In fact, in this particular point number G, too much has been said, though we can break it and discuss it differently, but let me summarize. Again, there is a mention of a fee which has to be reasonable. We have already discussed, we don't repeat, but it says needs to apply his mind. Now that's important. So if an IP has been given a charge, let him decide. And how do you know that what he's doing is right? So transparency, get that recorded, ensure proper disclosure, take CSC into confidence wherever required. I think you are done. After that, if you keep questioning everything, why you hired him, why you didn't, now who's professional, who's not, we are not out in the market to check the certificates and the pedigrees that way, because finally the IP is the person who's responsible. IBBI is holding the IP as responsible. You had to do the the avoidance, the prima facie opinion. You had to create a IM. You had to do this. You had to come out with a UI, RFRP. If we take support of people who are at different levels, right, of pedigrees, of professions, or whichever way, I think somewhere we need to give them the leeway. Number one, how do we ensure that there's no malafide, there's no hanky-panky happening? Again, I repeat, transparency, get that recorded, put that in COC, ensure disclosure. If you're doing it, then I guess fine. I'll even take a step further. I don't want to make it controversial, but there is something called, it can't be a relative of an IP. Can it be a relative of a CD? Can it be a relative of a banker, FC, OC, anywhere, anybody else, but not of an IP? My point is, if my relative is a professional, I'm not suggesting, I'm saying it's an anomaly. And what are we trying to achieve? If my relative is a professional, right, he's as good a professional or probably better than somebody outside. I have my comfort. You are going to catch me because I'm going to deliver or not. Till the time I disclose it, COC is aware, I have recorded it, everyone should be happy. So that's, again, small point. I might have taken it to the next level, but I continue to repeat the previous part, that till the time everything is above board, give the benefit of doubt to the IP. He's the guy who's driving it. What kind of a team is getting into? Let's not get into that. And I'm sure, if he compromises on the quality of his team, then his quality, his deliverables will be compromised, and he'll be the person whose neck is on, this thing is with you. So that's other thing. Of course, reasonableness and all, I'm not getting into. We have already discussed. It doesn't have a parameter. Second point, next point is appointment of registered valuers. I think dust has settled. You've said that very much in as many words. Unless until a registered valuer, it means a registered valuer with IBBI and two of them and no influence by the third party. I think that's very loud and clear. I don't know why, if at all, there have been cases where people have not been able to understand, and if there have been very specific issues that they have grappled with, then they need to sort it out with IPA or IBBI. So I think I'll skip it. Otherwise, absolutely, this is fine. Two people required, and that's it. Though it's just on a lighter vein, the last line is so that it does not drive out qualified and regulated valuation professionals out of practice. I wish you were equally concerned about the insolvency professionals being driven out. So it's the valuers only. But anyway, so that point is valid. Next point is payment for professional services. This is all connected. But this point is valid, that no payment should be going to a third party who's not been engaged. So the payment can only go to people who have been engaged, and that's on record. And if we are good with that, then I think let's look no further. Otherwise, there's no end to start with a skeptical mind and then go deeper, because at the end, somewhere we need to have the trust, and you have full authority to ask anyone as a at a random in a random way to kind of give the disclosures in addition to anything if you want. But otherwise, as I said in the previous case, leave it to the discretion of the IP, who's the driver, who's the person who gets appointed and who gets authority as per section 1718 to hire professionals or people to engage. You have him reporting into you. He's the person who's eligible or rather accountable to deliver. Any compromise he does with his team will show a compromise in the delivery and he'll be jacked. So he's playing with fire if he does something wrong from that perspective. So that was, again, a small repetition, but we move forward. Disclosure of fees and relationship, I think it is pretty much okay. Disclosure, it's all connected. Relationships, disclosures, they have to be there. It's already a set law, so we are not debating that any further. Fee for authorized representatives is the next one. The view which has come from the ground is that the AR apparently has to devote much more time. Somehow on one side, the fee, the composition was not to be managed or determined by the policymakers. In this case, it has been done. So 25,000 rupees per meeting. Decide 25 is higher or lower. Maybe it's a very simple process in 1 or 2 cases, and he's getting 25,000 for doing nothing. But there are cases where the guys are struggling, they're slogging, and they have to kind of have so many meetings with LRTs association. The association not easy to handle, sir. I'm advising few of them, and let me tell you, the conflict of interest what we have in these retail level people is humongous. Versus a COC sitting in a COC meeting the members, so it's very different. So all I'm saying is it's inconsistent. If we really kind of thought that we don't have to get into the compensation determination, we did that in this case. And if we did it, some leeway needs to be given to the IP based on the AR's request, or which again can require a COC's approval. So I'm not wanting to give it to one person in terms of the discretion. Put it to COC in case they feel that something additional can be given, if at all. But otherwise, it's like putting a cap, and irrespective of what kind of a workload you have, how much you slog, you are being given 25,000. So what will happen is either the person is getting demotivated. At the end, I feel for them, because though it's a AR, a different nomenclature, but they are IPs like me. Tomorrow, if I get an option, I can be an AR as well. Right. So if there are people who are wanting to get experience and they are starting as an AR, I think that's great. But then that they're not looking at 25,000 rupees. Maybe a meeting in a month is 25,000 rupees is what they get. So let's kind of make it a bit flexible. Put it to COC and the RP, justify and say that okay, up to a certain level or something, they can kind of agree. A thought. Again, a suggestion. If you think it's like appropriate, then it can find a mention in the white paper. You want to add something here?
Yeah, I just wanted to tell you that why this 25,000 rupees was fixed, because the financial creditors here are the home buyers, right? Not every home buyer is buying a second or third home. There are people who are buying the very first home. Right. And they are already troubled and worried, and they have exhausted every means to pay off the EMI or whatever, and they are in distress as compared to the other stakeholders in a regular CARP. These are all individual financial creditors. You can call them individual financial creditors. They are not corporate financial creditors. Agreed. So if the fee of AR is too high, again it will be they'll be sharing the burden. That was the only thing behind fixing 25,000 rupees.
So sir, quick counter. I mean, if you allow me, I can quickly tell you a different side to it. IP's fees is in any case being discussed separately, right? Which is in any case going to be a bulk of it, right? Because IP is driving the rest of the process, which in any case has to be shared by n number of people. One. So 25,000 or a higher amount, when it's distributed over a good higher denominator, it'll come to peanuts. One. Other point is, not every such case of class of creditors means only the home buyers or LRTs. You can have a bank, you'll have one FC, two FC or something. It gets apportioned across and it's going to be a CRP cost. So at the end, there might be a resolution applicant who is going to pick up the tab and all. So I think, yes, it was good to be concerned about the allottees who are first buyers or second buyers. That's that apart, but good to be concerned. But all I'm saying is the picture is much bigger. So maybe we've gone too much in detail to try and save the home buyer, but the same home buyer gets represented by the AR who is, if not motivated properly, who does not, if he gets proper compensation, he's going to lose motivation. He's not going to put in the best. And who's the sufferer? The same home buyers who are in whose favor we are trying to think about. So that was a small counter.
No, the larger picture, was. This, if IPs who are not so much experienced, if they volunteer, they come up to be authorized representatives, that will help in the sense that that will be an experience for them. It will be a precursor for them to take up bigger challenges, to get to know, understand. I'm not saying that experienced IP should not come. Experienced IP should take it as a little charity, because they are already, well paid and well remunerated. Let the new IPs be encouraged to be authorized representatives. This is only an informal suggestion.
Valid. Absolutely. That's a valid point. It was just about the compensation part, where even if we are talking about a new IP who's just coming into the profession, but sir, we have created a threshold where the guy has to be 15 years experience. So, I mean, are we doing justice in terms of, so all I was trying to link is the kind of effort which goes in versus the cap, which is already there. So effort can go up and down, but the cap remains. So maybe we can make it variable. That was one suggestion, but your point valid. And at the end, it's left to the IPs to kind of, give their consents accordingly. So if there is a bar or there's a constraint, then the other party will have to take a call accordingly. So that point is fine. I move to the next one. Representation in judicial proceedings. It says there are instances where the IP failed to represent the CD in judicial proceedings. So this would again be an exception as far as I think we are concerned, because otherwise, when the powers of the board are suspended, one challenge has been, is representation before the judicial proceeding a power? Now, ask me, generally the discussion we've had in our groups, that's not the part. So it's a duty for all the people of the CD, all KMPs or whosoever, to continue and support the RP. But no decision can be made unless until RP's concurrence is taken or a final approval is taken. So representation of judicial proceedings at that level, existing people, if they're cooperating and if they are available and they are competent, then they need to go, of course, with some authorizations. But otherwise, either the professional himself, if possible, because the bigger the client, the bigger the cooperator, the bigger the operations, you will have so many of these proceedings happening in parallel. So you would have your team or someone in your team who's capable of representing you as a professional with the authority taken from you and with your appointment letter, so that the other people know that who you are and why you are there. So that point is otherwise very valid. So I don't know if there have been some exceptions, then there should be a good reason for that, and then person should be able to explain. I move to the next one, related party. Again, this is covered by section 28. It does not require much of a debate. It's very clear. No related party transaction can happen without the consent of the COC, irrespective. So essentially, that means as far as the IRP is concerned, till the time there's no COC, then he has to put a hold to these kind of transactions, if at all. Otherwise, post COC, once the COC is very much in action, then RP has to take approval. So I move to the next one. Payment to creditors during CRP. So reading this kind of gives a small view which is inconsistent with what happens on practical, in practical way. Essentially, sir, what happens is it's not about payment to financial creditors. It's very clear. A bank, NBFC, they broadly understand. There have been few cases where they have apportioned or rather appropriated a fixed deposit or some funds lying with them, which was not to be done. Adjudicating authority was approached, they gave some orders, and eventually, the transaction had to be reversed. So that's fine. The problem is primarily about the vendors. Right. Now, what happens? Think about from their perspective. Again, I'm not wanting to change the law immediately, but I'm saying, like, let's be mindful and let's see. Are we saying that somehow to manage the operations or, like, ensure a corporate data continues a going concern, there is some flexibility which is required. Otherwise, if we draw a straight line, it's going to, like, it might be harder on the vendors, and it might be then, like, scuttling the process and probably reducing the chances of the revival. To ensure a company or corporate data runs as a going concern, you need to rely on a vendor. And a vendor to me is someone who's, like, provider of service. I mean, a service provider, a good provider. If they've not been paid earlier, if they've not been paid for, like, their previous dues, and you expect them to continue to supply you against all odds, because there is Section 14 moratorium, or there's an order, or you are an IP and you are concerned about the city and not about them. Their simple query is that, guys, we'll go bankrupt. Trying to help you to revive a corporate debtor, we'll go bankrupt, and tomorrow you'll be appointed in my case also. And then this chain will continue, because these are primarily MSMEs. So all I'm saying is, leave it to the, I mean, again, not good, wrong word to leave it to the discretion of the IPs, but maybe taking COC's approval, which is not going to be easy to come, but somewhere, let's not be harsh, try and rely. It's going to be, like, difficult, and that's the reason I thought I would really need to kind of raise this issue. All I'm saying is, if you're not paid them for their previous dues till the time of initiation of the corporate insolvency date, it's really going to be a challenge to kind of keep forcing them to continue to supply them, so that you ensure the corporate debtor continues to be going concern. Otherwise, there's a chain effect. So somewhere some thoughts need to be around this. A suggestion which came was, the money is fungible. So whether you are paying them now for the previous dues, or for, as an advance for the future or for the present, money is fungible. Figure it out. I mean, get into a bit of mediation, make them sit, let them understand, tell them that this is money is there, but please don't apportion it. Don't link it to the previous dues. Let those dues be there. But for the current one, I pay you now, and I pay you in advance, which means either you get a COC's approval, or you raise an interim finance, which again requires a COC's approval. But in case it's not coming, then reach out to adjudicating authority. I mean, the last resort, but try and give a ear to the operational creator or the vendor. Is going to be very important. So this thing apparently does not recognize the practical problems or IPs of the live companies are concerned, where you need to run the operations. And you cannot run the operations unless until you get the support of the vendors. So that was a small, clarification, which I thought it will be there. Next point is avoidance transactions. So what I've underlined here is, there are instances where RP failed to independently apply mind to such transactions and file applications in respect of them, and they allowed himself to be directed by the COC. So the only point, of course, 19.2 and avoidance transactions have, like, a similar fate in the courts. We have seen in NCLTs, they are taking whatever time in terms of disposal. But independence of an RP, yes, it's important, because he has to take a prima facie, he has to create opinion. But taking information, help, assistance, and discussing in the COC meeting is very important, because again, I say COC comprises of the financial creditors who've been dealing with the corporate debtor and the KMPs for much longer. They understand. They might have had the forensics prior to this. They are able to give a lot of inputs. So somewhere it's not about getting under the influence or something. I think again it should be a more of a team effort, where the objective is same. If there is something which has been done preferentially, fraudulently, or whichever way, then that needs to be unearthed and needs to be brought out. So that was one, but the problem continues to be the delays in disposal. So if that is not happening, then it's giving a flip and unnecessary confidence booster to the people who are actually, the culprits, or the people who started all that, including the promoters and others. So that is almost like similar to 19.2, where if about, and especially the example you've taken, High Court judgment a couple of days back. So if we are saying we can try and give the urgent symbol or label to both of these, that avoidance transaction and 19.2 together, Of course, 19.2 will take precedence because that can happen unless until I have 19.2 getting disposed. I won't even have enough information to understand about the avoidance transaction. So in a sequence, both of them need to be taken as urgent applications, not only 19.2. That is the point. Supply of information is more of a generic thing that whatever needs to go to whosoever, only that needs to go to that particular person, not without the undertaking. So that point is fine. We're not getting into too much of detail here. Confidentiality undertaking is almost similar. That okay, information cannot be given unless you take the confidentiality undertakings under 29.2 or whatever. And if some people have done something or a potential RA has got something without, I think those would be exceptions. They'll keep recurring, and we need to kind of really understand that. But I mean, there are 200 people who are participants, so I'm sure that nobody willfully would be wanting to kind of make these kind of mistakes. And in case there are some issues, then my suggestion, get that recorded, make it transparent, so tomorrow when you are questioned about it, you have a ready answer why it happened in the first place. So it can be a unknowing mistake or something, but it needs to be there that you followed a process. Disclosure of information is something similar. Yeah, Radhika?
Sir, sorry for interrupting in between. Sir, can we have a question and answer session for 10 minutes and then you can continue?
Okay, so, okay, then my suggestion, let me just take 5 more minutes. Let me run through it. Unless until it's really kind of very important, I'll probably skip. I've been skipping some of them now. At best 5 minutes, right?
Sure, sir.
So circulation of minutes is fine, sir. Window for views is something specific to the class of creators. I think it slightly became complicated in between, but it's settling in. Circulation of minutes. If there's a delay, why there's a delay? If we have recorded, then we are good with that. But so the problem is Saturday, Sunday gets counted in those 48 hours. Diwali, Holi gets counted. Though the people who actually get the minutes, they wake up whenever they wake up. So there have been some issues, but otherwise, yes, to the best of our ability, we always try 48 hours means 48 hours. We take it as a rigid, a mandatory thing. Inclusion of cost in IRPC, there have been many circulars, so I think broadly people understand when everything is above board, COC's approval and all, then only it should become part of the cost. Compliance with applicable laws. This is one thing which always becomes a bone of contention, and whenever you think it's appropriate time, we need to have some detailed debate. Compliance with applicable laws, nobody has a clue, including listed companies, what kind of laws are applicable on them, what kind of a list. Do we have a exhaustive list somewhere that I can start ticking the box? And the counter which we are making, again, as coming as a collective suggestion, is when a company is in CIRP, it's a distress asset. The guys have it's an NPA. They have not been adhering to so many other laws. They have not been paying up the TDS. They have not been depositing the GSTs. They have not been adhering to the PFs and all this. Not been filing returns. I mean, some of their directors' DINs have been suspended. So much of problem happening. Now, why on earth an IP is expected to comply with all the laws when his prime objective is to save the company? God forbid something goes wrong, the company goes into liquidation, eventually dissolution, everything is dead. What exactly I was spending my time on? Right now, that continues to be a concern. I'm not at all favoring or promoting or suggesting that I would do whatever I feel like, irrespective of whatever law is applicable. But I'm saying there is no conclusive, exhaustive list anywhere. Second thing is, there's too much of compliance in any case for me. When IBC is overriding, IBC was overriding because of a certain reason. Section 238 gives a non-obstante clause, gives a non-withstanding, the ultimate sweeping powers, because unlike any other law, prior to IBC, we never had a situation that the company will actually be a dead company. A legal entity will cease to exist. And the whole idea is the resolution or saving the company. So maximization of value, saving the company, resolving, restructuring, everything will happen. But let me not be saddled with something which has been plaguing the company for long because it's already a stress asset. So the promoter, the TMPs, they did whatever they did. They did not do whatever they could not, intentionally, non-intentionally. But putting that load on IP, apart from the other compliances, what we have, and the larger objective of saving the company, I think, is really taking their attention away from the larger objective and getting into something which is otherwise, probably can be irrelevant in the larger scheme of things. So a suggestion which has come again and again, and I would really, suggest and urge you to kind of take it up, think hard on this. The moment the company goes into CRP, the compliances should get reduced to half. What are those half? I don't know. Maybe again we can get together, put our heads together and see. These are important so that there is no allegations, there is no fund problem, movement, transparency is ensured, all that is fine. But maybe half. But the moment there's a liquidation order, again I'm saying compliance is zero. It was signing of a death warrant. The company now has to be stripped of the assets. I have to sell everything. What kind of a compliance I'm talking about? Half of the people in the groups are still struggling. Are we supposed to file this? Are we supposed to get this audited? Are we supposed to hire them? I mean, where is the focus? Focus post liquidation has to be on the maximization of the recovery. So get the maximum distributed. And prior to liquidation, CRP, focus on the resurrection of the company, restructuring. Things can all fall in place eventually. So this is something I really want to be put at the top because that's important. It's disturbing our natural flow and it's disturbing our creativity. It's just like binding us on something which is unknown. So applicability of all laws is a very, very general, open-ended statement. Nobody has a clue. We're trying to ask someone to help us prepare one list. We know that, okay, all this has been done, even if it's 100. But my point is, do we still, does it really kind of help? Is it a productive exercise? Let's discuss. So this was, very important. So timelines is fine. Compliance with orders goes without saying. Maintenance of records, I think, again, that's clear. Cooperation with inspecting authority, I don't need to say anything. If there's inspection, of course, people want to be comfortable that you guys have been doing everything which was supposed to be done the way it was the way it was mentioned. So again, nothing to add here. So okay, one query is, and let me kind of hold it back. So fine, Radhika, I think I've quickly completed the rest of them. If you want to raise few queries, and because we'll try and wrap it up in next maybe 10-15 minutes. Mr. Kumar, is that okay? 15 minutes on a.
Can we wind up by 1:30?
Okay, so let's hurry it up. I mean, that's always the case, but participants and friends, I think because I had collated these queries, they were not or suggestions and feedback. They were not everything on my own. It was a collation, so most of them indirectly, directly would have got answered. But otherwise, as I said in the initial phase, that I'll request Radhika to kind of compile everything. And suggestions and feedbacks will probably take a shape of a white paper and will get circulated apart from the recording. So Radhika, over to you on queries.
Yes, sir, we have already compiled it. Miss Nitika will take over.
Okay, sure. Ritika?
Yes, sir. So the first question is, for the matters needing interpretation, whether it will be better to create a separate cell at IBBI instead of referring by IP to adjudicating authority, because every time the IPs needs to go to adjudicating authority, and this creates more load on the adjudicating authority. So to offload the work of adjudicating authority, can we create a separate cell? So maybe Saji sir, you can give your inputs.
Very interesting question. The established standard of Insolvency and Bankruptcy Board of India is that we don't interpret the law, the code, the regulations, or the rules, because we are making the regulations, and if we start interpreting it, I don't know if that is appropriate. Interpretation of law should be by the judiciary, by the adjudicating authority, and the professionals have to apply their professional mind to read and understand the provisions. So that's a difficult area for us to create a cell which would interpret the code. What authority IBBI has to interpret the provisions of the code? We can only say that this is what the code says. But in individual cases, if IBBI starts interpreting, there will be market distress again. and mistrust too, because one process is different from the other. The scheme of IBC is that the state has created certain entities, including IBBI, and a law is provided, and it is for the stakeholders to play and not to interpret. If there is any issue, we have to only approach the adjudicating authority.
Great. And Nitika, I'll probably just add here. So you're right, sir, that interpretation cannot, come back to you. But I had a suggestion which I thought, like, no, I'll give it later, but now it becomes appropriate to kind of just add in here. So the idea is not to seek interpretation from you, but you are the author of the regulation. So to know the intent of the author is for sure important. Now, if I know the intent, if I'm not able to kind of, understand. So interpretation or application in a particular set is one, which probably is left based to judiciary. But knowing the intent is always, it should be an option given or a platform available so that you say, we've written this regulation because that's what the objective was, that was the intent. And if not happening, then we are happy to understand or explain. So what my suggestion was, the department or the cell, what they're saying is, I thought if a department internally, whether it's a combination of IPS putting it together with, IBBI's representation, it's essentially to handhold respective IPs who have issues, right? Where we just handhold them in telling them, I'm putting in some mediation in, frankly, but all I'm saying is they are grappling with a particular challenge or a dispute or something like that. And there is a mechanism. It's more of saying that, why don't you try this out? Why don't you try this out? At the end, it's an IP who's getting a kind of an advice, which is non-binding, the way they get from stakeholders committee and all that, but they get from a select people, right? What happens if they are okay? It'll help them to probably try something out and settle the matter rather than reaching out at the drop of a hat to NCLT. I think so. What the suggestion or the query was, I have tried to merge it. Intent is not to interpret. Intent is not to tell them that file or not file. We are saying, did you try this? Did you try this? Can this be done? Did you, did you think about it? A couple of those things. Otherwise, if all that mechanism has been exhausted, then please reach out to adjudicating authority. Simple. So that was, a suggestion. I don't know whether it's premature or over the period it'll
No, the only thing is that it should not be binding.
It's not.
Opinion. Yeah.
Absolutely. It's not opinion, a view, a suggestion, a guidance given, but to the IP when he's getting bothered. When he's grappling on the ground, now reaching out to adjudicating authority requires a time, effort, and increases the load, infrastructure, all those issues. Is there a mechanism where he knows that there is a cell or a department where he says that I'm suffering from this, what can I do? What are the options? And based on, the ability for us to react or respond, of course, nothing comes binding, nothing comes in writing or something, but some suggestions, and the guy says, okay, I didn't think about it, let me try it out. And if it fails, then the last resort by default will be the adjudicating authority. So maybe I think that'll be a good thing, to kind of discuss, mull over it. I am not sure what kind of a shape or composition it will have, but a thought. And now if you want to kind of add a couple of your thoughts on mediation, we can actually link it here. Because to me, this is such an amazing thing where it can have a lot of benefits across the CRP and liquidation, pre, during, post, at every stage. So you wanted to, share your thoughts. Probably now we can link it to this department of cell.
Yeah, the mediation, of course, your suggestion is well taken. Mediation is very important. Although code does not talk about mediation, the regulations also are silent. But in the personal guarantors to corporate debtors regulations, you would have found one particular regulation which provides for, it's an enabling provision since there is no, right. Since it's only an enabling because there is no power under the code. So we facilitate mediation through that. Of course, that was a new thought that has come to IBBI. And I understand that government is pursuing mediation, conciliation, and other methods of alternative dispute resolution, methods.
Right.
to to be applicable to insolvency matters as well.
Right.
Government has already taken up a project. Some thoughts have already been given, and I think it is in the pipeline. It is high time for us to settle the dispute. Sometimes some small talk, informal chat
Yeah.
would help the parties to come to a settlement, and settlement can be achieved through mediation. There is another area that is being developed is ODR, online dispute resolution mechanism,
Right.
wherein many things can be settled even pre-admission. The
Yeah.
moment we file an application or notice is given under Section 8, many things can be settled before the matter is actually admitted, and many opportunities can be given to the parties because admission has far-reaching consequences. So
Yeah.
admission procedure should also be eased out.
Right.
As you suggested, there is a need to take up the matters with the adjudicating authority, even the registrars and other staff members. There are areas where we find things are not so good. So we need to solve those issues. And I think IBB has to take lead in being a mediator in this, between the IPs and adjudicating authority and the staff on the other side. We will
Right.
include government also in this. And
Right.
over the period of time, this branch of the alternative dispute resolution would also be developed in IBC.
Right, sir. So, sir, good to know that government is mindful of it, and they're working on the mediation part, and it finds some enabling mention in the individual insolvency case. But you are the author of the regulations, right? Why not take the lead and at least put through the regulations that mediation should be tried in whatever way in CRP also? No harm. Again, you are saying it's an enabling provision, but the moment it's there on record somewhere, at least people will start talking about it, thinking about it, let it evolve over the period. And that's something which is within your, area.
No, but there is this little, legal issue involved in this, because the mediation process should reach a finality. It's the kind of settlement arrangement that that is happening should be enforceable, right? If it is not enforceable, there is no point in having mediation. The settlement should be written down in black and white, and the parties should affix their hand. Only then it will become effective, and it should have the blessings of the adjudicating authority also. Then only it will become binding. That issue has to be tackled by incorporating a benevolent provision under the code. So PG to CD regulations, we only made a facilitation just to give an indication.
Got it. Got it. Fair enough. So, I mean, again, that's probably another thing. We won't spend more time on the mediation part, because I would suggest, because I've been doing webinars and interacting with a lot of people. So there's a way to handle that, and let that be again a topic for a separate day. Nitika, maybe one more query which finds a lot of repetition, so that it resolves a lot of people's view or query. Nitika,
Yes,
you wanna?
sir.
Yeah.
Yes, sir. We have received so many queries on fees related part and its recovery. So there have been some suggestions, one or two.
Yeah, so you can read out the suggestions, because we've agreed that needs to be taken up separately. It's a sensitive topic, and we've already spent about 10-15 minutes, frankly. So I understand the pain, the grievances, but I mean, beyond a point, let's not dwell further. If you want to read one or two suggestions and then go on to one important query apart from the fee part.
Yes, sir. So just the suggestions I'm reading out, so that IBBI shall take note of that.
You can send the suggestions, Nikita, to us. I think we will take up one question, which may be the last question.
Right.
Suggestions, please jot it down and send to us. As Mr. Ahuja was saying, will be giving us some feedback from this.
Sure, sir. So, sir, one of the major issues which the IPs generally face is that delays in order of discharge for RP by adjudicating authority. So that affects the complete CRP process and its compliances. So this is the issue which the IPs are facing. So this may be addressed.
Yeah, because the discharge depends on, the other person, takes charge. So in order to avoid a gap, this has been made, because the IP is not released unless the other person takes charge. Because there have been issues when where there were nobody, in the process, just as the process. That's the reason it has been made. If there are still issues, we will deal with it.
Agreed, agreed. So essentially, what you're saying, right? You cannot leave the entity headless, right? So the baton has to be handed over either to the liquidator or to the resolution applicant. And I
Yeah.
guess there was an amendment last year or a year prior to that, some section 16 or something, where RP will continue till the time he's discharged through a order of the NCLT. So I think
Right.
yes, maybe what the concern might be that the moment the filing of the final application has been done, right, under section 30 or something like that, then the compliances and all, I mean, RP has to be exempted from there, because then he's kind of done everything. He's just a custodian after that. And is he really in control? So maybe some clarity is required there. So I think that was the last query. And sir, I have just one last point, which apparently was not covered, and it's more of a statement, a suggestion, a request by a lot of IPs. They're saying we've seen the disciplinary orders, right? And the suggestion, the request is it's a dampener. Like we get to see one of our colleagues really getting hanged up there on the website of IBBI, which is a window to the world. Right now, whatever damage it does, unless until there is a willful default or a mens rea, right, in true sense. Now, those are good cases for an action, and someone to be there as a as an example, as a deterrent for the rest of them. We are finding that there are a lot of cases where we have a procedural and technical issues or some violation, which absolutely are more likely than not, they are unintentional. People are learning, it's evolving, and there are issues practically. So getting delayed, not able to put a particular report in time or something. Now these are not, they cannot be compared with a situation where there is a fraudulent or a malified intent, or a, as I keep saying, mens rea. So maybe we need to distinguish between these two, and let's go softer on on one part of it, because it's coming as it's coming as a pain, as a dampener, and also a shame, frankly. So on one side, we are saying it's a new profession. The world is looking at us, the World Bank, these are doing business, and they're saying they have 3,500 guys, and every now and then there is someone who's like, hanged out there on the website. So is there a way, to kind of reduce that? So that came as, suggestion.
Okay, you send out the suggestions. I'm not able to comment on this because this is the action taken by disciplinary authority.
I understand, sir.
Yeah.
Yes. So we may not be able to put everything in writing as well. So we thought like it's a good way to speak. But
Okay.
great. I think we're done. So thanks a lot. And so thank you for, sir, candid answers. And I guess we have taken, some queries. I really apologize for, not being able to take all the queries from all the participants, but let's hope we'll get more opportunities to kind of interact with you and your colleagues from IBBI. So I put it back to the host and for the final comments. Thank you, Mr. Kumar.
Thank you. Pleasure.
Thank you so much, sir. The session was indeed very informative, and major queries were answered well. So I would like to thank Saji sir and Sanjeev sir on behalf of ICSI IP. Well, thank you, sir.
Thank you.
Okay, and please ensure the white paper and the collation. That'll be important for all the participants as well.
Sure, sir.
Okay.
It will be
Great.
done.
Thank you. Thanks,
Okay,
everyone.
thank you so much, sir.
Take care.
Appu chal.